Marijuana law is complex, sometimes conflicting, and often confusing. What's clear, no matter where you live, is employees may not use or possess marijuana at work. Employees may not be under the influence of marijuana while at work. And employers have the right to reasonably enforce a drug-free workplace, even in states where marijuana is legal. What's less clear is where this leaves legal users of marijuana. What happens if a registered medical marijuana cardholder has a positive drug test? How about someone who uses marijuana recreationally, but only when they're not at work? To date, 35 states and the District of Columbia have legalized medical marijuana. In most of these states, employers are not required to accommodate medical marijuana use. This means that an employee can be fired or have a job offer rescinded because of a positive marijuana test, even if their marijuana use was legal under state law. However, more and more states and cities are amending employment laws to require reasonable accommodation for medical marijuana users. State and local laws may restrict when an employer can test for marijuana. For example, in Nevada and New York City, pre-employment testing for marijuana is illegal. Often, state laws prohibit employers from firing, failing to hire, or disciplining someone based on their status as a medical marijuana cardholder or a single positive marijuana test. State laws may also require an employer to make a reasonable accommodation for a medical marijuana user. The most common accommodation is adjusting the employee's schedule or granting a leave of absence while the employee is using the drug. Some state laws apply only to registered medical marijuana cardholders, while others also extend protections to primary caregivers of qualified medical marijuana patients. Many state laws provide an exception for employers who would lose federal contracts, grants, or licensing by accommodating medical marijuana use. To date, Maine is the only state to protect off-duty recreational marijuana use. Arizona, Arkansas, Connecticut, Delaware, Illinois, Maine, Massachusetts, Minnesota, New Jersey, Nevada, New York, Pennsylvania, and Rhode Island all protect against employment discrimination for medical marijuana users. The specifics of each law vary by state. Recent court cases suggest that medical marijuana users living in these states are more likely to be protected from termination or discrimination based on their medical marijuana cardholder status. However, there's no guarantee. It is always possible for a court to decide that federal law supersedes state law. As long as state and federal laws conflict, marijuana will remain a tricky subject for employers and employees alike. The best thing you can do is remain aware of the laws in your area and proceed with caution.